Why are you doing this? Why are you doing this? You cheated on me. I still have to go to the to my money. So it's mine. For goodness sake, it's mine. I said I can't be ready. I was even at 16. You come at 16. You still you're
The money is only yours.
Why?
You know the money is only yours.
It's mine.
I know you all are wondering what is happening here. As you can see, Moyo and Kofo are arguing about the trust fund set aside by Kofo for their marriage, which was later cancelled. They are trying to determine who will be the beneficiary to the trust, or if it will be back to the settlor. This is similar to the 1884 case of Eshe against Caroline, where a woman set aside a trust for money for a marriage, which was later cancelled. The court held that as the trust has failed, and the money is to revert back to the settlor as a resulting trust. What is even a resulting
trust? This is an equitable version of trust that arises by operation of law whenever a person has created an expressly intentional trust, but this express trust fails or does not completely dispose of the trust property. Its sole purpose is to redirect this trust back to the owner. Yeah, the settlor is also the beneficiary. Here are some ways by which resulting trust can be created.
A resulting trust to be created when an express trust fails.
In Boys vs. Boys, an express trust was created in a will by a father for his two daughters as to how two houses were to be shared between both of them. It stated that the eldest daughter was to pick a particular house, any of which she prefers, and the youngest daughter was to pick the remaining one. However, before the will could be executed, the eldest daughter died, and there was a dilemma as to which house was to go to the youngest daughter. And so in this particular case, the express trust failed, and it resulted back into a resulting trust whereby the two houses went back to the father.
When the beneficial interest under an express trust isn't fully disposed of.
When the express trust is not fully disposed of or exhausted. So this means that when an express trust is not fully disposed, when the trust is created and it is not fully exhausted, it is to pass back to the settlor or the testator. This is established by the case of Riobabu Pedro, where the settlor created a trust for the grandchildren, for the children and the grandchildren, solely for their education. And after their education, there were still some trust fund left, and the court held that it should pass back to the testator. Also, we have the case of Ray Andrews, where the friend of the deceased clergyman, he created a trust for the children, for the education of the children, and then the trust stated that it is created solely for the education and not to be shared equally, or for it to be used solely by one person. So the court held that the trust has to be shared equally among the children, because a trust for a specified purpose is an absolute trust, and a trust for a specific purpose is a trust for the benefit.
When a purchase is made in the name of another, or when one makes a voluntary conveyance of his property to another person.
When a person purchases property in the name of another person, the law usually assumes that the buyer did not intend to give away such property as a gift. Instead, there is a rebuttable presumption that the person in whose name the property was registered actually not doing it in trust for the real buyer. Here, there is a resulting trust because the buyer actually intended to keep the real ownership for themselves. See the case of Ukata vs. Unego, where Ukata actually advanced 2,000 naira to Umego to help him purchase the land, with the understanding that the land shall belong to Ukata. But Umego actually went against this and registered the land in his name. So the court actually held the favor of Ukata that since he advanced the money for the property, it shall belong to him.
This is based on the presumption that such a purchaser intends to retain in a beneficial interest in himself, and this can be seen in the case of Koka vs. Koka.
Our trusts are not expressly stated but are implied from the intentions of the parties. A perfect example of this is when a property is purchased in the name of another person. There is this presumption that the property is being held in trust for the person who purchased the property.
So in the case of Madu versus Madu, Grace Madu, the applicant, applied for a land in Abuja and requested her husband to complete the process. The land was acquired, but the land was bought with Grace's money. But upon the completion and the allocation of the land was registered in her husband's name. The court held in favor of Grace, in that the land was held in resulting trust.
Another case that best explains the principle of resulting trust perfectly is the case of Obika vs. Obika. In this case, the plaintiff's uncle was managing the properties of the plaintiff's father when the plaintiff was still 4 years old. And in the process of time, just before the plaintiff became an adult, the plaintiff's uncle bought the property in dispute with the money made from the plaintiff's father's estate. And while the plaintiff became an adult, he requested for an account and for the building in dispute, since the building in dispute was bought with money that was made from his father's estate. Only the court hold in the case of Obika vs. Obika, the court actually held in this case that the plaintiff's uncle only bought this property or held this property in resulting trust for the plaintiff, notwithstanding the fact that he bought the property in his own name.
Addition to general principle is the presumption of advancement, which arises when a person purchases a property and takes out conveyance in the name of another with whom he has a special relationship, such that he has an obligation to make provisions for that other person. In other words, rather than a resulting trust to the purchaser, it becomes a gift or advancement to the other person. Or documentary evidence is admissible to reduce the presumption of advancement and establish that the purchaser intended the purchase to be a resulting trust.